This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to talk about why it is important when you file suit with regard to an insurance claim that you only sue the insurer. You have no right to sue an insurer for fraud in claims handling in the state of Oklahoma and many other states because it simply will not meet the conditions and limitations of an action for fraud. John R. Parrish sued alleging claims for breach of contract, breach of the duty of good faith and fair dealing, and fraud against 3 defendant insurance companies. The claims arose out of the defendant's handling of an insurance claim submitted by the plaintiff Parrish for storm damage to his home. In John R. Parrish v. Liberty Mutual Insurance Company et al., a November 18, 2022 decision of the United States District Court for the Western District of Oklahoma, the homeowner's policy that plaintiff relied on was issued by Defendant American Economy Insurance Company. The other 2 defendants, Liberty Mutual Insurance Company and Safeco Insurance Company of America, are alleged to have handled various dealings with plaintiff and have participated in the claims handling process. All 3 defendants moved to dismiss the purported fraud claim, arguing that Oklahoma law does not recognize a fraud claim in the alleged circumstances. Defendants Liberty Mutual and Safeco also moved to dismiss the contract and bad faith claims as to them, since they did not even insure Parrish. A court will grant a motion to dismiss if the complaint fails to allege enough facts to state a claim to relief that is plausible on its face. The court accepts all well-pleaded factual allegations of the complaint as true and views them in the light most favorable to the non-moving party. A claim is facially plausible when the plaintiff pleads factual content that allows the court to draw the reasonable inference that the defendant is liable for misconduct alleged. The fraud claim, however, is only allowed in Oklahoma for fraud in the inducement of the contract, or as to the types and amount of coverage which are examples of fraud allegations allowed with regard to insurance matters in Oklahoma. But that is not the circumstance alleged by Parrish. The plaintiff raised no issue on how plaintiff's claim was handled once a claim was made under the policy. In that context, where claims handling practices under an insurance contract are at issue, Oklahoma does not recognize a fraud claim. For example, in Lewis v. Farmers Insurance Company, a 1983 decision of the Oklahoma Supreme Court, that court stated that Oklahoma law recognized the 2 causes of action which may be asserted premised on the existence of an insurance contract. 1, an action based on the contract, and 2, an action for breach of the implied duty to deal fairly and in good faith. The result is that here, where all the claims are premised on the existence of the contract, no fraud claim is available to the plaintiff. The court concluded that Oklahoma law does not recognize a claim for fraud where the challenged conduct is the handling of a claim under an otherwise valid policy. Defendants' motions were therefore granted. Defendants Liberty Mutual and Safeco contended no claim is stated against them at all, as they did not issue the homeowner's policy involved, and therefore cannot be liable on it or as to the duties arising out of it. Plaintiffs argued that the extensive actions of Liberty Mutual and Safeco and their employees in handling the claims are sufficient to make them liable on the contract and bad faith claims, even though they were not a party to the contract. Silly. The petition alleged that all three defendants are part of the same insurance group, that they advertised together in various ways, and that employees of Liberty Mutual and Safeco dealt directly with plaintiff and handled most or all aspects of the claims adjustment process. Plaintiff contended that that is enough to make them potentially liable. The petition does not explicitly allege that Liberty and or Safeco are instrumentalities of American economy, nor, more importantly, does it allege facts that would support such a conclusion. The petition does, to be sure, allege substantial involvement by employees of Liberty Mutual and Safeco in handling plaintiff's claim, but without more. The suit only suggests a basis for concluding that Liberty Mutual and Safeco were agents of American economy, not instrumentalities of it or of each other. Since neither Liberty Mutual nor Safeco are alleged to be parties to the insurance contract, and since no plausible basis has been alleged here for concluding they were instrumentalities of the contracting party, the petition does not state a claim against either of them. For the foregoing reasons, American Economy's partial motion to dismiss and Liberty Mutual and Safeco's motion to dismiss were granted. The fraud claims were dismissed as to all defendants. The contract and bad faith claims were dismissed as to Liberty Mutual and Safeco, and remain as to American economy. In my opinion, because of mergers, consolidation, and specialization, insurance holding companies operate multiple different insurance companies with different names, different specialties, and management. To save expenses, the holding company will employ the same staff of underwriters and claims personnel to handle claims for all of the many insurers under the control of the holding company. Each insurer is an individual entity that shares personnel with its sister insurers. In this case, only American Economy insured Parrish, and only American Economy could be sued for failure to fulfill the terms of the contract or for the tort of bad faith. The suit against the other insurers was simply an attempt to annoy and vex the holding company and draw more money from it. It didn't work. The claim for fraud couldn't be proved in Oklahoma, since anything done in the adjustment of the claim could fulfill the need to prove all of the elements of fraud, and that simply they did not exist. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the URL zalma.com/blog. And you can subscribe to the blog so you miss none of my blog posting, usually published 5 days a week, sometimes one on each day, sometimes more. And you might also subscribe to this video at rumble.com or at youtube.com. And I'd appreciate it if you either click on the Rumble button or the like button if you do watch the video. And I'd suggest you subscribe to the video on one of the services so that you miss nothing. And if you found this video to be useful or interesting to you or your colleagues, please tell them so that they can also subscribe to the blog and to the videos. And you might also wish to subscribe to my locals community and my Substack publications, where detailed information is published that is available only to subscribers. Thank you for your attention.